Well, good morning or good afternoon, as the case may be, to everyone. Thank you for joining us in sort of this new virtual world of CLE presentations. We are going to be presenting on kind of an interesting topic, at least to me and to our panelists. It is, as many of you may know, the CARES Act, which came out at the end of March, amended the FCRA, the Fair Credit Reporting Act. And John Ulzheimer is with us today, who is a credit reporting expert. And I'm going to be discussing with him the background of the FCRA, just because I want to make sure everybody is on the same page in terms of what it stood for, what the law was prior to the amendment, and then what the CARES Act has done in terms of an amendment. We plan to spend about 20-ish minutes on background, and then the remaining part is really going to be a question and answer for John Ulzheimer. I have some questions, and I hope and encourage those of you on the line to send in your questions via chat. One sort of disclaimer, this is not intended to be legal advice, and John is not a lawyer, he's an expert. So I will do my best to give information on legal questions. Also, with regard to specific questions on what code would be used in any particular situation, as many of you may know that are familiar with credit reporting cases, there is a big book, a code, the CRRG, that John would typically refer to in terms of what exactly to report. So likely he's not going to be giving advice on any particular hypothetical scenario. But really the discussion is designed to talk about the CARES Act and the amendments to the FCRA. So with no further, and I will say, just because I ran into this, so it was a good prompt for me, just a reminder that in today's world, we're dealing with new technology, yours truly included, and just when I think I've mastered WebEx, I have not. So it may be that we run into technical issues. I hope that we do not. But if we do, hang in there. We will get it up and running again and fixed. If anyone has dogs barking or children scurrying and pounding on the door, it won't be something we haven't experienced, but please keep your phones on mute. All right. All right. And so, as I mentioned earlier, John Ulzheimer is with us today. John Ulzheimer is the president of the Ulzheimer Group, LLC, and founder of www.creditexpertwitness.com. He's a nationally recognized expert on the credit reporting and credit scoring, as well as identity theft. In addition, his expertise includes not only the FCRA, but also the FDCPA, and the CROA. This includes expertise in credit reports and credit score damages. He's been retained as an expert witness and a legal consultant in credit-related litigation over 400 times, has been qualified and is admitted as an expert in both state and federal courts. John is twice FCRA certified by the Consumer Data Industry Association, which is the trade association related to credit reporting agencies. He has 28 plus years of experience in the consumer credit industry. He has held positions, and this is somewhat unique for a credit reporting expert, with the CRAs, with Equifax Information Services, with Fair Isaac, which some of you may know as the inventor of the FICO score, with Credit.com, and years of concurrent work with numerous other credit-related companies. John has been published many times, over 5,000 times in the past 16 years, on the topic of consumer credit. And you may have caught him on television as well. John has contributed content for CNBC's On the Money, for Freddie Mac's Know Your Score campaign, for Oprah Winfrey's Debt Diet series, for Carbonite's Breach podcast. He's a frequent commentator on credit-related issues in various outlets, including USA Today, Fox Business, the Associated Press, CNN, CNBC, the LA Times, Fox News, the Washington Post. The list kind of goes on and on. John is kind of the preeminent expert in credit reporting. And I can say I've had the pleasure of working with John on a number of occasions, both in trial and as we work a case up for trial via declaration or consultation. For those of you that don't know me, I am Kristin Walker-Probst. I am a partner here at Womble Dickinson in the Business Litigation Group. And my expertise is both in trials and issue spotting casework. And I've spent the last 15 plus years in the financial services industry, which obviously includes the Fair Credit Reporting Act. As I mentioned, I've had the pleasure of working with John. I can think of at least one, if not two, trials that we've actually done together. And I can say in both, as well as with some CLEs we've done, after the trial was over, I had jurors and staff come up to me and say their favorite witness was John Ulzheimer, that he made credit reporting interesting, and that he was a lively witness. And I can agree with all of that, and I hope you find that to be the case today. All right. Let's start with some background. So just to make sure we're all on the same page, the Fair Credit Reporting Act, or what we call affectionately FCRA, is a statute that governs the collection, maintenance, and disclosure of consumers' personal information. And it regulates both consumer reporting agencies, what we call CRAs, or furnishers. And furnishers is defined as parties that supply consumer information to credit reporting agencies. Finally, it also regulates, although I'm not sure that it'll be applicable today to the CARES Act amendment, but it regulates third parties, such as a dealership that would request and use a consumer report. And so I want to start for a second with what is a consumer report. I care about this to some extent with evidentiary issues when we get to trial, because there's some presumptions made by many that some things are consumer reports which are not. What a consumer report is any written or oral communication that meets the following. It needs to be prepared by the consumer reporting agency. So Equifax, Experian, TransUnion. It needs to bear on the consumer's creditworthiness, their credit standing, capacity, their character, their general reputation, personal characteristics, gender, things like that, or mode of living. And it needs to be used to collect or collected to establish a consumer's eligibility for a particular purpose. And as you know, and I think we'll talk about this in a second, one of the FCRA areas of the statute is if a consumer report is pulled for a wrong purpose. Again, I don't think the CARES Act touches on that portion of FCRA. Actually, John, if I can involve you just for a minute, because it happens all the time. This slide goes through what a consumer report is. Can I get you to elaborate on what it is not?
Well, in my world, the consumer report, so consumer report is kind of a category of reports, and a credit report is an example of a consumer report. There are a variety of other consumer reports that are in the commercial marketplace and used by companies for various, including risk mitigation. But in my world anyways, the primary variety of a consumer, actually there's two types of consumer reports. There's the hardcore garden variety credit report, which is the Metro 2 produced or the Metro 2 formatted report that lenders and other service providers use, that they're pulling directly from one or more of the credit reporting agencies. And then there's the consumer disclosure report, which is often referred to as a credit report incorrectly, but it's too complicated to try to explain the difference between a consumer or a credit report and a disclosure. But a disclosure would be something that a consumer would have direct access to, perhaps through one of the credit bureau's websites or annualcreditreport.com. And it is a kind of a cosmetically reformatted version of a credit report, but just for consumer consumption. So for example, a bank or a credit union or an auto dealership would never pull a disclosure and make a decision off of that information. And likewise, a consumer would never pull a quote unquote credit report because they don't have access to that native data at the credit reporting agencies, and neither of the two shall meet unless you work for a mortgage broker and you're pulling your friends' credit reports through their system. And so the question is well, aren't those really the same thing? And the answer is not really. A consumer disclosure is designed for, like, my mother to understand. It's color coded. There are legends that explain what all these different numbers mean. Red means something, yellow means something, green means something, and it does not necessarily include all of the information that you would see, for example, in the credit report's credit file, the credit bureau's credit file databases about a consumer. A credit report, conversely, is essentially a series of comma delimited alphanumeric and alphanumeric characters that, unless you know how to read two, really wouldn't make much sense to you, because it's a series of numbers and letters, and it's generally something that's machine readable and accessed in a system-to-system environment by a user from a consumer reporting agency like an Equifax or a TransUnion or Experian. And that's important to differentiate between the two, Kristin, because whenever whenever we're involved in these credit FCRA cases where there's an allegation of credit damage or harm to a credit score, it's uncommon, or it's not uncommon, to have a consumer disclosure style report introduced as part of document production and kind of presented as evidence of credit damages or something that could result in a lower score. And scoring systems are, we tend to talk about FICO and VantageScore as scoring systems that are almost humanistic in nature, when in reality they're not. They're software, and they read data, and the data that credit scoring systems read is the Metro 2 data that's housed with the credit reporting agencies. And so that's why I think it's important to draw a line between a credit report and a consumer disclosure, because even though the two terms are used interchangeably, they're absolutely not the same thing.
And what about, just for those of us that handle in litigation, for instance, a plaintiff or a consumer sends over in discovery something he or she pulled off of, say, freecreditreport.com or Credit Karma or any of these other resources. Is that a consumer report?
Yeah, it's definitely, well, and so we're getting further and further away from an actual credit report, right? I mean, you have, if you were to go to, if a user of the information, meaning a lender or an insurance company, goes to Equifax, for example, they're pulling a credit report directly from the source. There's no degree of separation between that transaction. Now you have, all these different websites, the Credit Karmas and the Credit Sesames and Mint and Bankrate, all those different companies that have broker agreements with the credit reporting agencies to buy in bulk large amounts of data and then turn around and either resell it to a consumer or give it to a consumer in exchange for you becoming a registered user of their website, like in the Credit Karma scenario. So now we're more and more degrees of separation away from an actual credit report, because just because, say, an Equifax or a TransUnion provides this universe of data to these websites, it doesn't mean that website is going to turn right around and give that information to the consumer in the same form or format. They may give an abbreviated version of it. They may give a version of it that includes their own kind of cosmetic overlay of the information with links and explanations, and the formatting might be different. And so while yes, it's definitely something that I think the layman would define as being either a credit report or a credit report summary. It's absolutely not Metro 2, and it is absolutely not something that was furnished to a credit reporting agency by a bank or a credit union or a credit card issuer. And that's where we get into this. That's where we get into this confusion of, well, what's the meaningful information to use? Is it the actual credit report, or is it something that is being provided by a third party like a Credit Karma or a Credit Sesame?
And I focus on that just because we may want to use those sort of third party depending on strategy, but also there's, for instance, hearsay objections and things like that that may be applicable. John, if you could sort of briefly explain how the information cycle works. So we have furnishers, as we talked about before, providing information to the credit bureaus. How does that information get relayed both from the furnisher to the credit bureaus and vice versa, from the bureaus back to the furnisher?
Yeah, so this is kind of a combination of the what came first, the chicken or the egg, and then also a little bit of acronym salad. People in my world tend to speak in acronyms, and so I'm going to try my best to not speak in Metro 2 and rather speak in English. So, you know, it depends on who you believe. If you believe the CFPB, there are 10,000 furnishers of information. If you believe TransUnion or the credit bureaus, there's actually closer to 15 to 18,000 companies that will report information, which is defined as furnishing, to one or more of, and let's just call them credit bureaus, because consumer reporting agency can include companies that we're really not going to be talking about today. So I'm just going to refer to them as credit bureaus because that's really what we're talking about. So you have all these companies like, you know, John's Bank and Joe's Credit Union that furnish information usually on a cycle basis, which is usually once per statement cycle, which means once per month, to one, two, or all three of, or four, there's four of them actually, of the credit reporting agencies. And they'll generally do that using some sort of system to system or tape reporting method. And now when the credit reporting agencies get this information, there's this presumption that, you know, if you can kind of think about an old-fashioned manila folder sitting in an aluminum file cabinet somewhere, that there's some massive file cabinet with hundreds of millions of these files in it. It's certainly not how it's organized. Think of the credit bureaus as gigantic pools of information, and in the pool, floating around in the pool, are literally billions and billions of account level information attributes. And that information is not associated with any particular credit report at that time, right up until a user of the information, like a bank or a credit union, asks for it. So in other words, they make what's referred to as a credit inquiry. And when they make a credit inquiry into the credit bureau's database, the credit bureaus use very, very sophisticated matching logic. We could spend 5 hours talking about that, but we're not going to bore the crowd with that baloney. They use very sophisticated matching logic to associate information that's floating around in the pool, if you will, with a particular consumer. And using that matching logic, they actually compile a credit report of information that they believe is associated with the consumer whose identity matches that of the credit inquiry that was submitted by the user of the information, usually, again, a bank or some sort of a financial services company. Once that once that report has been accumulated from the file database, then it is almost always run through a scoring algorithm or multiple scoring algorithms. So FICO, VantageScore, some other custom scoring system that may be hung with one of the credit reporting companies. And then that information is magically, submitted or delivered electronically to the user of the information. That entire process that I just explained takes literally a couple of seconds. It's not a long process. So now you have a credit bureau that's created a credit report from the credit file system and has delivered it to the furnisher, who then uses it to make some sort of decision. Usually it's an approve, deny, or modification to the terms of an account. And if they do have an account with the consumer, then they report that information to the credit bureaus. And so it's kind of the symbiotic relationship between the two parties, right up until the consumer decides that something on his or her credit report is wrong. And then they can file a dispute. And the dispute can either be filed directly with the credit reporting agency, or they can file it directly with the furnisher. If they file it with the credit reporting agency, the credit reporting agency creates a form, and the form is called an ACDV, or Automated Consumer Dispute Verification Form. Before that, if you ever see ACDV and you also see CDV without the A, those are the same things. The CDV is the predecessor form to the ACDV, and the only difference is the CDV is not automated. So the ACDV is the same form, just in an electronic format. The ACDV is then sent to the furnishing party using a communication protocol called eOscar. And eOscar, think of eOscar as a sophisticated telephone line, if you will. And furnishers can log into their eOscar account. They can pull down all of the ACDVs, and then therefore they can see what of their customers is disputing information and what information they are disputing. And of course, that's when you have your obligation to perform your investigation and respond in a timely manner. If the consumer contacts the furnisher directly, meaning that they circumvent the credit reporting agency, that's called a direct dispute. If you contact the credit reporting agencies directly, that's called an indirect dispute. And that's important because different forms are used when you're filing a direct dispute versus an indirect dispute. If you file a direct dispute with a furnisher directly, the furnisher obviously is going to perform their investigation, and they're going to kind of in a one-way communication type of scenario, they're going to send a form called an AUD, or the predecessor form was called a UDF, called a universal data form or an automated universal data form. And that's basically the furnisher telling the credit reporting agencies, hey, look, we received the dispute directly from one of our customers. We want to modify our reporting, and we're using this AUD in order to facilitate that update. And the language that they communicate back and forth is in fact this Metro 2 format. So there's all these different codes in the fields where the codes are appropriately placed. And that's all driven by the Metro 2 guidance, which is the booklet that Kristin referred to earlier, which is about some 290 pages and is updated every single year by the Credit Bureau's Trade Association.
Thank you, John. A little bit of that WebEx technology glitch I mentioned. So just running through, and I'll do this fairly quickly, common claims under the FCRA. The two I think that are impacted by the CARES Act amendment are the first two. And the first one is the failure to follow reasonable procedures for ensuring accuracy of consumer information. There's an obligation to report the consumer's debt accurately. And we see there are state analogous statutes that have a little bit different elements, but this concept of reporting accurately is one of the ones that I see most often in terms of litigation. The second one is the failure to properly investigate or re-investigate the consumer's dispute, which is what John was just talking about, when the consumer believes there's something inaccurate and they either make a direct dispute with the furnisher or an indirect dispute with the credit reporting agency. And then the final one is if someone either issues or obtains the consumer report for some impermissible purpose. Not for review of credit, but for some reason that they shouldn't be pulling that private information. I don't believe that that third prong is impacted by the CARES amendment, but we can put that in the question and answer session if someone has some thoughts on that. So culpable mental states under the FCRA, and this matters in terms of exposure. So there are negligent violations or willful violations. Negligence is just what it always is, kind of under the law, is did the defendant act reasonably? The prima facie case requires the plaintiff to not only show unreasonableness, but there must be a causal relationship in whatever their damage is to the supposed inaccurate reporting or investigation. And that causal relationship is important because without it, that means there is no damages, there can be no punitive damages, there can be no attorney's fees, there's just no case. For willful violations, and it's kind of a relaxed standard from what many of us view willfulness or the Webster's definition of willfulness may be, it's defined as a knowing or reckless violation of the statute. And the reason this matters, whether it's negligent or willful, is because of the damages and remedies that are available. So for all, whether it's negligent or willful violations, costs and reasonable attorney's fees are available. But because in a negligence violation, there has to be a causal relationship, one of the defenses is causation, and we use that rather frequently. If it's a willful violation, the plaintiff can elect whether they seek actual or statutory damages. And if they seek statutory damages, which can be anywhere between $100 and $1,000 per violation, then they're still entitled to attorney's fees. So absent some actual damage being caused by the inaccurate reporting, if there is a technical violation and the plaintiff can establish it was willful, then they are still entitled to attorney's fees and unfortunately punitive damages. For negligent violations, there's no punitive damages available. It's just actual damages caused by the violation. One of the issues, though, is that negligence, the damages associated with the negligent violation can include emotional distress damages. So we can get those, the exposure can be ramped up if you're dealing with a sympathetic plaintiff. And I would imagine as we sort of enter into the future after this COVID-19, we're going to get even different types of emotional distress types of claims that may resonate with the jury. And interestingly, although not music to my ears, is that unlike a lot of the consumer statutes, no cap on statutory damages in class actions. So that $100 to $1,000 per violation, there's no cap on that. So now we get to the CARES Act and what the CARES Act has done. It amended section 1681 S2A1F. And basically what it did is it added the following. If the creditor or furnisher provides an accommodation, and I'll pause there for a minute because that word is not well defined, or it's defined, but it's so vague that I don't find it helpful. If an accommodation is provided to a consumer that was affected by COVID-19 in connection with their account, then the furnisher must report the consumer account as current, unless it was already delinquent, and we'll talk about that in a minute, for the covered period. And the covered period is January 31st, which predates the CARES Act, which was not enacted until March 27th. The covered period is January 31st through, I think it's either 120 or 180 days, 120 days, either from the date of the CARES Act or the date that the president declares the disaster over. And so we've got sort of an amorphous covered period where there needs to be a reporting of current. If the consumer was delinquent prior to the accommodation, then the furnisher can continue to report the consumer as delinquent unless and until the consumer brings the account current. And then it must be reported as current through the covered period. So maybe sounds clear, but John and I think it creates plenty of issues. To complicate things maybe even further, although I think my end weigh in on this is the CFPB isn't going to affect litigation under the FCRA. But the CFPB weighed in on, I think it was April 1st, immediately after the CARES Act became law, and interestingly stated affirmatively that the CFPB will take a flexible supervisory and enforcement approach during the pandemic. And they recognize that there will be operational issues that are created for furnishers given this change in reporting, and that as long as they will consider that in terms of the operational issues in terms of enforcement actions and regulatory actions. Now, that nowhere is this sort of lenient, more liberal and taking into account the operational difficulties found in the FCRA. So for purposes of litigation, I'm not sure that the CFPB's policy is relevant. And in fact, sorry, we have a visitor. In fact, the Attorney General has weighed in and actually criticized the CFPB immediately afterwards. So I'm going to turn this now, since we've gone through the law and the changes in the CARES Act. to questions for John in terms of what we're looking at now. And I'll weigh in to the extent it's relevant. Maggie, I'm letting you sort of look at those. Do we have any questions from the audience yet?
Not yet. John, are you there to respond?
I'm here. Yes, ma'am. You mean our first 32 minutes was so good that no one had any conceivable question? Well, let me throw myself a really easy softball question, because let me tell you the question that I've gotten ad nauseum since the CARES Act became the CARES Act. And the reason I bring this up is because this has been covered by a lot of the national media and also kind of the blogosphere, the financial services blogosphere, and some of them are getting it right and some of them aren't getting it right. And so I want to clear up any confusion that may have been inadvertently caused with respect to some of the credit reporting options that furnishers have and have had long before COVID-19, and what is the practical impact of some of those reporting options. So, Kristin, we've talked about this, that the word accommodation is so, it could be anything, right? It could be the waiver of a fee. It could be, a settlement on a debt. It could be anything that a plaintiff's attorney can think that they can kind of shove within the box of an accommodation. And one of the accommodations that potentially a furnisher can make is some sort of a modification or temporary modification to the terms of an obligation, such as deferred payment or forbearance. Forbearance is getting a lot of attention right now for mortgages and also student loans, but also payment holidays. So credit card issuers will sometimes give a payment holiday around the holiday season towards the end of the year. So I those things I think could reasonably be defined or positioned as being an accommodation. And then the question is, well, how do you credit report that? And right now that's the magic question. And there are, there's no shortage of opinions, but I can tell you that from an expert's perspective, so from someone who is going to end up having to write expert reports and give opinions on the impact of furnishers reporting during the covered period, this I can tell you what the impact is of some of the reporting options of accommodations. And so here they are. So remember earlier we talked about how Metro 2 gives this really long inventory of hundreds of different ways to report trade lines with codes and such. And two of those codes that are getting the most attention are the disaster code and the forbearance code. And so those are what's referred to in Metro 2 as special comment codes, or SCCs. And so if you ever see SCC when it pertains to credit reporting, those are probably special comment codes. The special comment code is simply a code that adds context to your trade lines when it appears on a consumer's credit report. Some special comment codes are considered by credit scoring systems. Some special comment codes are not considered by credit scoring systems. And so therefore, you may report something along with one of your trade lines, and it may or may not have any influence over the consumer's credit score. And so let me give you a couple examples. The forbearance code, the special comment code for forbearance is the letter CP, CP. So if you report a CP on, for example, a mortgage, if you're a mortgage servicer or a lender, and you're furnishing that information to the credit bureaus, then your trade line is going to show up the next time someone accesses that particular consumer's credit report or disclosure as being in forbearance. That particular code in and of itself has no impact on the consumer's credit score. So if someone was FICO 750 before you reported the CP code, they're 750 after you reported the CP code, right up until something else that's not related changes on their credit reports and causes their score to be different. But you're not going to harm someone's credit score simply because you are now reporting them as being in forbearance. You're also not going to harm their credit score if you report that they have been influenced by the natural or the declared disaster. That particular special comment code is represented by the letters A, W, like the root beer, A and W. The AW Special Comment Code was not created for COVID-19. The AW Special Comment Code has been around for decades. On a credit report, it reads, affected by natural or declared disaster. In my 28 some odd years in this business, I have never seen the AW disaster code used for anything other than people who live in a part of the country that has been affected by a hurricane or some sort of other kind of weather disaster. So like Hurricane Hugo or Hurricane Harvey, people who live in those areas, it's not uncommon, or at the time anyways, to see the AW disaster code associated with the trade line on a credit report. Just to let you know, these special comment codes are trade line specific. So if you were to report one of these codes with one of your trade lines, it's only going to show up associated with that particular trade line. It's not going to be globally associated with everything that appears on the consumer's credit report, but just your trade line. Now, obviously, if your peers are also going to report the CP code or the AW code or any other special comment code, then that too would be associated with their respective trade line reporting. The AW code, so there are two primary credit scoring systems that have basically 100% of the market in the United States, FICO and VantageScore. The AW code for FICO scoring is actually very simple. It's entirely cosmetic. And so if you were FICO 750 before the AW code, you're FICO 750 after the AW code. For VantageScore, it's a little bit more complicated. It's not as simple. The AW code, if it's associated with a trade line, will prevent any negative reporting associated with a trade line from impacting the VantageScore credit score. So if you were 700 prior to the AW code, you might be 780 after the AW code under VantageScore's more contemporary generations of their scoring systems. Once you remove your AW code, then the trade line becomes fair game again under VantageScore's scoring systems. And so if they're 780 before the removal, they may be a 700 after the removal. This isn't, you're not causing score damage. You're just allowing the score to revert back to its normal organic state. So if you read things like, well, the AW code doesn't affect your score, that's a little bit misleading because the AW code itself, the special comment code, isn't causing your score to go up or down. But what it is doing is, in the case of VantageScore anyways, it's causing the scoring system to treat the trade line slightly differently than it would have otherwise. So I think that's something that Kristin, anyways, I thought was important to clarify, because there's a lot of reporting with respect to forbearance in the AW disaster code that isn't necessarily correct.
Kristin and John, we're getting several questions in. Is this a good time to throw one out? Given that a furnisher's liability under FCRA arises from a furnisher's failure to reasonably investigate a disputed report, doesn't a plaintiff have to first dispute how an accommodation under the CARES Act is reported before suing under FCRA?
You want me to handle that, John? It's sort of a legal question. I think that's, we've worked together long enough to know. So I think that answer is yes. In order to meet a prima facie case under that part of FCRA, there would first need to be a dispute, and that would be the dispute, is that the accommodation code was inaccurate or should be changed. Presuming that the plaintiff has done that, then they could bring a claim under FCRA.
Hey, Kristin, is there an exception for the California version of the FCRA that it?
There is. It's not really an exception. It's just there's no such thing as a investigation. So under the FCRA, I think it is California, there is just the obligation to report accurately. There's not that second prong about investigations and disputes.
So where this could come up, just to kind of put some acronyms to the question, Virginia, is, so if your client or if the debtor disputes how the lender is reporting something to a credit bureau, and the lender or the credit bureau sends the dispute form to the furnisher, and the furnisher performs their investigation, and what I think you're going to see, obviously no one can predict the future, but I think what we're going to see is we're going to see FCRA lawsuits for incorrect reporting per the CARES Act amendment, meaning that, hey, you gave me an accommodation and therefore you should have reported me as being current, but you didn't. You kept me, you kept late payments, or you kept reporting me late, and therefore my credit score was unfairly harmed, and therefore I couldn't get a loan or I couldn't refinance my house. That's what I think we're going to see. Is we're going to see, this. I think I had an accommodation, and therefore you should have reported something a certain way, rather than in the pre-CARES Act world, it probably wouldn't have led to an FCRA lawsuit, because accommodations pre-CARES Act did not require any sort of modification to have. So in other words, if you waived fees, or if you waived a late fee because you missed your credit card payment 1 month, so you waived the $39 late fee, I think you can make an argument that's an accommodation. Or I can definitely see a plaintiff's attorney making an argument that, hey, you made an accommodation for my client, they caught up, and therefore you should never have reported them as being delinquent or late, all the way retroactive back into January 31st, when the cover period began. So I think you're going to see some interesting kind of back to the future types of language in these complaints, given that we're talking about this now, but we really have to kind of retroactively think about how you credit reported way back on January 31st of this year.
I don't disagree, John, although it just seems ridiculous that certainly the CARES Act is silent on some affirmative duty to go back in time and change. It's ridiculous that the CARES Act came out on the 27th and the covered period predates that. But I agree with you that if there's a dispute, and I think it would come up, the consumer would be viewing themselves as receiving an accommodation and therefore believes they should have been reported as current. And so they would dispute that. And then I think there may be an obligation to go back and change the reporting even before the CARES Act, back to January of this year. At least arguably there would be.
Kristin and John, we have another question that's kind of interesting. A credit reporting agency, one of the major ones, is offering to boost a credit score if you sign up for one of their sponsored card. What does this do for the legitimacy of the credit reporting agency?
So that's, I will admit that I was not aware of that. I'm certainly familiar with Experian Boost and their marketing campaign to get people to sign up for Boost, which it doesn't lead to, what it leads is to your utilities being reported to your Experian credit report, and potentially an increase in some of the more contemporary generations of the FICO score based off of that data.
And that's who it is that is in fact saying that.
Okay, so yeah, so that's real. That's not fictitious. Experian does have this new product. I mean, they're not charging for it, so it's kind of, I don't know if calling it a product is fair. But yes, you can sign up for. I did it. So I took the consumer experience just so I could talk about it intelligently, and to the extent that you feel comfortable giving away the login and password to the bank account that you use to pay your utilities, which is what you're going to be asked to do, then using a process called screen scraping, a third-party company that Experian is partnered with will actually get that information and report it to Experian. Experian will place it on your credit report. And in FICO 8 and FICO 9, the two most current versions of their score that's commercially available, that your score potentially could go up because of the newly added utility account information. My score went up 6 points, and so I took the consumer experience, and my score went up. My score went up as a result.
And I had some questions come in before this even started from folks. So I have a question, and I know predating the CARES Act by maybe even just a couple days. I think it was Fannie that came out, Fannie Mae, in mid-March with a lender's letter that was directing servicers to suspend credit reporting. Now, clearly, the FCRA is going to trump that, but that kind of directive, what is your opinion on whether suspending credit reporting is a good thing or a bad thing?
Yeah, and that actually, that's actually a similar question, I think, was just submitted about 10 minutes ago. So if you look at the list of questions, there's a similar question that almost paraphrases your exact question. So I think it's a horrible idea, and here's why I think it's a horrible. First off, that's if Fannie, Freddie, FHFA, or some other really large influencing body is successful in convincing a large number of furnishers, or even a small number of furnishers that provide a large number of trade lines to the consumer credit reporting agencies. Let me explain from a practical perspective, exactly what that means. I understand why you would be a little bit, you would be nervous about furnishing information in the world of the CARES Act, because so many things are not terribly well defined, like what is an accommodation? What does current mean? How do I really have to go retroactive with my reporting? So I understand that there's some nervousness, and I'm totally with you. But here's what suspending. So in my world, you can either suppress credit reporting as a furnisher, you can delete, or you can cease reporting, or you can suppress your reporting. And the two words are not the same, and they have very specific meanings. And so I'm going to make sure that I give the example for both, because I think you're going to see the words used interchangeably incorrectly. And I just want to make sure that everyone has an accurate understanding. Suppression, which I think, Kristin, is the word you used in your question. Suppression means to actually remove and prevent the reporting of a trade line on a credit report. And if you read the FCRA, there's actually language in there from, I think, the FACTA amendment in 2003 that obligates the credit bureaus to block information from being re-reported if it has been confirmed fraudulent. And the practical method that the credit bureaus use to prevent the accidental re-reporting of fraudulent information is called suppression. And so that's why I think it's important to get this word out there and define it correctly, because if we just start throwing around the word suppression, that actually has a very specific meaning. And this is the best way. If I was explaining suppression to a jury, this is how I would explain it, because it's hard to explain it using kind of credit vernacular. If you have a dozen eggs in a package that only holds a dozen, and you remove one of those eggs, you leave a hole, and that hole can be filled with another egg. The same thing occurs with credit reporting. If you delete something from someone's credit report, you leave a hole there, and the furnisher can re-report it the next time they report, which is usually the next month, and therefore you'll fill that hole with potentially incorrect information if something is simply deleted. Because of the language in the FCRA with respect to blocking fraudulent information, the credit bureaus use a process called suppression. Suppression, instead of deleting that egg, will actually just mask it or hide it. You don't remove it, which means you don't allow the furnisher to re-report the same thing accidentally next month. You actually leave the egg there, and so you can't put another egg in the slot because there's still an egg there, but you just can't see it. So from a credit reporting and credit scoring perspective, it's gone. The consumer can't see it, the credit scoring system can't see it, and therefore it can never be re-reported because the place where it would have gone has already been filled with something. So if the suggestion from Fannie, Freddie, or FHFA is to really suppress your reporting, then that would mean that you are actually asking the credit reporting agencies to essentially mask millions and millions and millions of your trade lines for some period of time, and therefore it cannot be re-reported until they remove the masking or blocking of that information. If what they really mean is they just want you to temporarily stop updating the trade lines, which is what I hear people using the word suspending. And really what you're doing is you're going to leave your trade line on the credit report. The information will be visible not only to the consumer, it'll be visible to lenders, and it'll be visible to credit scoring systems. Let's say that you didn't update your trade lines any more recently than last month. And so let's say that everything you furnish to a credit reporting agency is based on your March update. And let's say now that you listen to their guidance and you have suspended your credit reporting for some foreseeable period of time that we don't know, because no one knows when the covered period is going to end. you're basically going to leave that trade line on a consumer's credit report for some undefined period of time. It's going to be, it actually already is stale. It's a month old. The information is wrong. The balance is incorrect. The payment history may not be accurate. You may have changed the credit limit if you're a credit card issuer. There's so many things that you could change on a monthly basis with respect to your updating of a trade line that within a month or two, it's going to be hard to argue that the information is valid any longer. So, okay, so who cares? This is why I think it's important to care about that, because the next time the consumer goes and applies for something, the credit score is going to be calculated partially based on your information that's X number of months old, and therefore the data that they pull from the credit reporting agencies, the credit bureaus probably would argue with me on this one, but I would argue that the data is less valuable. The scores that are generated are going to be less reflective of the consumer's actual risk. And if you use any custom scoring systems that you use, or anything in your application processing systems, use the data off of a credit report to determine things like debt to income ratios and capacity metrics, then that information is going to be based on something that was reported all the way back until January or February or March of this year. So I hate the idea of stopping your credit reporting for some period of time because of all of those potential issues. And I can tell you, I can't speak for the CDIA, but I sat through a webinar that they had not more than a few weeks ago, and they said the same exact thing. So I don't think anybody really wants the credit reporting engine to be shut down like that. And look, if it was, Joe's Bank and they have 2,000 customers, that's one thing. But the minute you start suggesting that large mortgage loan servicers that have millions and millions of trade lines, or credit card issuers that have tens of millions of active trade lines, or large auto lenders that have tens of millions of active loans, the minute you start suppressing that information or suspending your credit reporting of that information, I think that it may help you temporarily, but I don't know that it helps the consumer at all. And in fact, it could be very problematic for the consumer.
Well, and arguably it would be compliant with the amendment. So if there was some type of damage that could be articulated, there could be a case.
So isn't there language, Kristin, in the CARES Act amendment that you shall report it as current? And again, I will never ever pretend to be a lawyer. And in my world, if you start trying to give legal opinions, you have the big Daubert. You get to wear the Daubert necklace, and no one wants to wear that necklace ever. But I don't know if the word shall in my mind means that you will do it, rather than you'll choose not to do it because someone else has told you should suspend your credit reporting.
I agree. So to me, the defenses are you didn't give an accommodation, or they weren't current, or there's no damages caused. And that's only argument. The latter is only an argument that's available if it's a negligent violation.
Yeah, I mean, so there's two ways to think about all these things. There's your way to think about it, meaning what are the legal merits of the argument? And then there's my side of it, which is, well, was their credit reporting compliant with Metro 2 standards? Is there really any damage or harm to their credit score based on the credit reporting? Are there really any adverse action letters or any sort of true proof or evidence of harm, credit-related harm? So that's my side of the argument. On my side of the argument, there are tons and tons of ways to rebut any opinions about harm and damage caused by this. But I don't know that helps prevent what I think is going to be this wave of lawsuits that are filed if lenders choose to report certain ways that aren't necessarily. In my opinion is, look, if the act says you have to report current, if someone has an accommodation, then you report current, and then you kind of, I hope anyways that you prevent being on the wrong side of these, what I think are going to be a whole lot of newly styled FCRA lawsuits.
Kristin, we have about 5 minutes left and a couple more questions. One is, if a borrower obtains a COVID forbearance accommodation from a creditor, but files bankruptcy before the COVID emergency ends, should that borrower be reported with both a SW code and a bankruptcy code?
So that's kind of a hybrid between, the kind of the accommodation credit reporting and then what are the Metro 2 guidelines? And so the Metro 2 guidelines were, so the 2020 version of the Metro 2 manual or the credit reporting resource guide has not been published yet. The 2019 version is the most current version. Well, the 2019 version was published before the coronavirus. And so there's nothing in the 2019 version of the manual that gives any guidance with respect to how to report based on the CARES Act, the temporary CARES Act amendment, because this amendment will eventually go away once the covered period ends. So, that's an interesting question that I don't think has a very clean answer, because no one has had to report under that scenario ever until at least, or as long ago as January 31st of this year. So I'm sorry, I don't have a really good answer for you, because no one's really ever contemplated this hybrid between Metro 2 and COVID-19 related issues.
We have another one for you, John. Do you foresee the credit industry adding a specific code for reporting credit events that result from the pandemic? If it did, would that be helpful to data furnishers hoping to take advantage of the CFPB's current flexibility?
So if I was a betting man, if you made me bet some of Kristin's money on this, then I would bet no, that they would not create a new code. And let me give you my reason for saying no rather than just saying no. Most of you who've been in the business for longer than 10 years remember the 08-09 meltdown and how all of a sudden short sales became a thing, right? I don't recall very many short sales taking place before the economic meltdown in 08 and 09, but all of a sudden we started seeing short sales all over the place, because that was a good way of disposing of a mortgage where your loan to value was out of whack. Well, there was no short sale, and there still is no short sale code in Metro 2. There is no way to systemically report the words short sale on anything on a credit report. So to the extent that the credit industry, it's not really the credit bureaus per se, it's the trade association that really is the keeper of the Metro 2 guidelines. They didn't create a new code to deal with that. And that was a multi-year thing. And you're still seeing short sales even to this day, a decade plus later. This COVID-19, this is a temporary kind of blip in time on our radar. This will eventually go away. This is, and Kristin, correct me if I'm wrong, I think this is the only amendment to the FCRA that actually has temporary obligations that will eventually cease to exist. So I don't foresee the trade association creating a new code for a variety of reasons. Number one, they will probably take the position that they already have a code. It's the AW disaster code. And that code should be used for people who have been affected by COVID-19 and want that code reported or associated with one of the trade lines. So there is an existing code, just like the short sale code. They ended up using a debt settlement code to deal with short sales. There was already a code already in place. Number two is all of your application processing systems that y'all use are coded to recognize the current version of Metro 2. If they added a brand new code to Metro 2, then all of your application processing systems would have to be patched or reprogrammed to take into account a newly created code that deals with this COVID-19 issue. That's another thing. Third, for all of you that use custom developed credit scoring systems, and most large lenders either have multiple custom scoring systems or an entire suite of credit scoring systems that they've either built themselves because they have the brain power, the internal capacity to do that, or they've paid someone to develop custom scoring systems. All those custom scoring systems would have to be rebuilt to some extent to take into account a new code that the system wasn't built to consider. So it's not as simple as just buying a new toaster and plugging it in and replacing the old toaster. It's a really big deal when you start creating new codes, because all of the pre-existing scoring systems and application processing systems are not built to recognize it because it didn't exist when that system was implemented. So I would suggest that the answer is probably no to that question for those reasons.
Kristin, we've just pushed up to the hour.
Okay. Well, John, it's always a pleasure. Thank you for joining us and for enlightening us on this. It's certainly an interesting time. And you are right. It's the only amendment I'm aware of that's temporal, which will make things interesting. Thanks to the audience for joining us. Everyone stay safe and have a good rest of your day. Thank you.